So the Supreme Court just issued a unanimous 9-0 decision which overturned a felon in possession of a firearm charge. So let's talk about this. But real quick before we jump into this video, if you believe it's time for the Supreme Court to once again uphold our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to thank the supporter of this video, which is Axle Ear Pro. Axle Ear Pro has a bunch of electronic ear pro. These are actually my favorites. It's their earbud because I do a lot of outdoor shooting. And so those are really good because I don't have to worry about the earmuffs actually having their seal broken by my buttstock. If you guys are interested, you can use the link down in the details section. And if you use the code ARMSCHOLAR, you can get 15% off of your order. So like it's in the intro, the Supreme Court just issued a 9-0 unanimous decision striking down attempts by a government agency to enhance charges against a man who they claimed was a felon in possession of a firearm. The case we will be talking about in this video is Wooden v. the United States. Now some background on this case. In 1997, Mr. Wooden and 3 friends broke into a one-building storage facility right next to his home. Mr. Wooden and his friends then proceeded to go unit to unit within the facility. They did this by breaking down drywall between all the individual storage units, and the men ultimately ended up breaking into 10 total units. Mr. Wooden and his friends were later arrested, and he ultimately pled guilty to 10 different counts of burglary. 17 years later, after that conviction and those charges in 2014, Mr. Wooden answered his door to a police officer who was there in plain clothes. The officer asked to speak with his wife, and the officer also asked to step inside of his house because it was cold outside. This police officer also did not identify that he was actually a police officer. However, once the officer was inside Mr. Wooden's house, he saw that there were firearms actually there. The officer knew that Mr. Wooden was a felon and therefore arrested him on the spot. Mr. Wooden was charged in state court with being a felon in possession of a firearm, but the case was later dismissed when the DA actually noted that there was no probable cause for Mr. Wooden to be arrested. However, Mr. Wooden's issues did not stop there. He was later subsequently charged by federal indictment with being a felon in possession of a firearm and ammunition. After Mr. Wooden was found guilty, the district court found during his sentencing hearing that he qualified as an armed career criminal under the 18 U.S.C. Code Section 924, subsection E. Essentially, what the government sought to do is to have Mr. Wooden's actual sentence enhanced under the Armed Career Criminal statute. The ACCA mandates a sentencing enhancement if the offender has 3 prior convictions for violent felonies like burglary or serious drug offenses that were committed on occasions different from one another. The government in his case argued that each of the 10 storage facilities that he was arrested for prior was a different occasion, and therefore Mr. Wooden should have his sentencing enhanced up to 15 years. On review, the district court agreed with the government that the 10 storage units should be treated as separate occasions, and therefore they enhanced his sentencing under the ACCA, giving him 15 years in prison. Mr. Wooden appealed his sentencing to the Sixth Circuit, but once again, the Sixth Circuit agreed with the government, finding that Wooden's prior burglaries were separate from each other, despite occurring as part of one single criminal spree. Mr. Wooden then sought Supreme Court review. The question presented to the Supreme Court was whether Wooden's prior convictions were for offenses occurring on different occasions, because the burglary of each unit happened at a distinct point in time rather than simultaneously. On review, the Supreme Court issued a 9-0 unanimous answer to that question, which was no. The court stated convictions arising from a single criminal episode in the way Mr. Wooden's did can count only once under the ACCA. On this basis, the court reversed the Sixth Circuit's ruling and remanded the case back down to the lower court. Now, one thing that is interesting that came out of this case was a discussion on the rule of lenity. If you're not aware, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the person, not the enforcement agency or the government. Now, why am I mentioning this discussion on the rule of lenity? Well, the rule of lenity has been advocated for in Second Amendment cases like the GOA bump stock case. This is because definitions in terms such as machine gun, if found to be ambiguous by a court and later used against people, would result in serious criminal penalties. Courts sometimes claim terms like machine gun are ambiguous in such a way that devices like bump stocks fall within that language. The argument against this type of interpretation is that the rule of lenity would direct courts to interpret the claimed ambiguous term in a way that is most favorable to the people, not the ATF. In this case, though, you had justices on both sides advocating for the use of the rule of lenity. Justice Gorsuch, in his concurrence, was one of the main advocates for the rule of lenity. He stated, Respectfully, all this suggests to me that the key to this case does not lie as much in a multiplicity of factors as it does in the rule of lenity. Under the rule, any reasonable doubt about the application of a penal law must be resolved in favor of liberty, because reasonable minds could differ, as they have differed, on the question of whether Mr. Wooden's crimes took place on one occasion or many. The rule of lenity demands a judgment in his favor. He went on to state lenity works to enforce the fair notice requirement by ensuring that an individual's liberty always prevails over ambiguous laws. He does, however, acknowledge that doubtless lenity carries its costs. If judges cannot enlarge ambiguous penal laws to cover problems Congress failed to anticipate in clear terms, some cases will fall through the gaps, and the legislator's cumbersome process will have to be re-engaged. But as the framers anticipated, any other course risks rendering a self-governing people slaves to the magistrates, with their liberties dependent on the private opinions of the judge. So there, Justice Gorsuch is pointing out something really important. He's pointing to the fact that some things may fall between the gaps in various laws, but it is not the job of the judiciary or of judges to expand laws or language. Their job is to read what language is actually there and then apply what Congress intended. If Congress failed to cover something in their own law, it is their job to go about the congressional process to expand and change that language. This is the basic framework our founders created. Congress makes laws, the executive carries out laws, and the judiciary evaluates laws. That is each of their roles. Now, surprisingly, Justice Gorsuch even received support from justices on the other side. Justice Sotomayor, in her concurrence, stated, "I agree with Justice Gorsuch that the rule of lenity provides an independent basis for ruling in favor of a defendant in a closer case." There was some pushback, however, against this whole use of the rule of lenity. For example, Justice Kavanaugh stated, "The rule comes into operation at the end of the process of construing what Congress has expressed, not at the beginning." He stated, "In short, because a court must exhaust all tools of statutory interpretation before resorting to the rule of lenity, and because a court that does so often determines the best reading of the statute, the rule of lenity rarely, if ever, comes into play." So there, Justice Kavanaugh is saying he acknowledges the rule of lenity, and maybe it could be used in some cases, but really it will rarely come into play in most cases because justices should turn to other things first. So this was really an interesting decision with a lot of moving parts. The ruling to deny enhancement of felony possession charges was the main purpose of this case, but I think the long-lasting impact of this decision will be the discussion on the rule of lenity. I no doubt expect to see this section and the opinions and various discussion on the rule of lenity to pop up in future Second Amendment cases, especially those which seek to bar the ATF from using vague statutory language to ban various items. So this is one of those cases that on its face may not seem important, but this whole rule of lenity discussion really can be important for future cases. So if you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I cannot thank you guys enough for everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this station is built by armed scholars. This station will be maintained by armed scholars.